This is case 2011-0803, the State of New Hampshire versus Kevin Michon.
Good morning. I'm Shawn Sweeney for Mr. Michon. Mr. Michon was charged by a complaint that initially alleged he was driving during a period, or driving after suspension. It was later amended to say that he was driving during a period of revocation. A notice from the revoking court, which you'll find in the defendant's brief at Appendix 1, informed Mr. Michon that the period of revocation passed. So, at the time he drove, he knew that he did not have his license restored. He also knew that the period of revocation was reduced. And the notice that he got from the revoking court telling him that the period of revocation had been reduced came with no other warning, no other information, no caveats whatsoever. So, at trial, the defendant intended to produce that notice to rebut the state's evidence that Mr. Michon's driving occurred while he was knowingly in a period of revocation. The trial court prohibited the defense from introducing that notice and thereby eliminated the defense. So in this case, the defendant's stipulations included that he drove a motor vehicle, he drove on a way, that he drove on April 7, 2010, when his license was in fact under suspension. And a key to this case is that a stipulation was that he was aware that his license had not yet been restored. So that's a substitution, actually. That awareness that the license has not yet been restored is a substitution for what in State v. Watkins is with knowledge that he is within a period of revocation. So there was a lot of discussion about what the stipulation would be in this case because Mr. Michon was not willing to stipulate that he was knowingly within the period of revocation, which under State v. Watkins is an essential element.
But if he knew, I mean, you construe the statute and the knowledge requirement, it seems to me, overly expansively. He in fact was suspended for DWI, right?
Yes, he was.
Right. And so he knew that.
He knew that he had been initially suspended, but then he got a notice later on from the court saying that that suspension had been reduced. And at the time he got the notice, that period had passed. So what he knew was that he was no longer within the period of revocation. That's what the notice said.
Right, but the point is he was still suspended. I mean, he didn't think it, because you stipulate he didn't think that he could start driving, right?
That's right. So that
you stipulate that. So I guess my point is this. My point is this. He knows that he has been suspended for DWI.
Yes.
And he gets this notice, as you say. I understand that. But he also knows that he still is suspended. So the suspension that he is still under arose from his being suspended for DWI, and it's still in effect that he's suspended.
So it's actually two different offenses. One of them is driving during a period of revocation, and then there's a lesser included offense, which would be driving without a valid license. Okay, so he committed the lesser included offense, the violation level offense, but he did not commit the misdemeanor offense.
You know, I would have no trouble with that argument, except that the stipulation isn't that his license had not yet been restored. It's that he was aware that his license had not yet been restored. Isn't that a problem in terms of knowing?
Absolutely. So he was aware that he had not yet been restored, but that's not the element under Watkins. So that's not the third element of the offense. The third element of the offense is that he had knowledge that he was within that period of revocation.
It doesn't really say that, does it? Doesn't it say that he did so with knowledge of the revocation or suspension? It doesn't say within the period.
You're correct. That's exactly what it says.
Right. I suspect the state's going to take that position, and that is significant.
So and the state could certainly take that position in a trial. And the wonderful thing about a trial, Your Honor, is that if the state takes a position that is patently unfair or flies in the face of defense's evidence, we get an opportunity to present the other side. And that's what we were trying to do.
Unless your evidence would suggest to the jury a misapplication of the law, that in other words, that it mattered whether he knew that or not.
That is true. Okay. And what I suggest, Your Honor, is that that evidence in this case directly rebuts the knowledge of that period of revocation.
So it's an entitlement to all proofs and defenses that you're raising.
That's absolutely correct.
And this particular is the scienter component of that.
I'm sorry.
It's the level of intent that you're seeking to defend against.
That's exactly right, yes, sir.
Thank you.
Good morning. May it please the Court, my name is Diana Fenton, and I represent the state of New Hampshire in this matter. The letter from the Manchester District Court informing the defendant that his period of license revocation had been reduced from 12 months to 7 months was simply not relevant, because the law is clear from this court that the period of revocation includes two distinct parts. There's the order of suspension and the restoration of the license. And the letter did not in any way indicate to the defendant that he was entitled to drive when that letter was issued.
But why not let that go to the jury? Especially nowadays with an apparent nullification issue afoot. Isn't it a defense? Excuse me.
The problem was it was an appropriate exercise of discretion by the trial court because, as Justice Lynn pointed out, it was simply a misapplication of the law. That letter was essentially...
Okay, but why isn't that a defense? I was confused. Granted, I violated the law, but I was confused, so I didn't intentionally violate the statute, Your Honor, or ladies and gentlemen.
It's simply a misapplication of the law. It flies in the face of the established law from this court in State v. Milner, which was a state cert petition.
That ignorance of the law is no excuse unless it's what is given, well, it's given by somebody in some position of authority.
Absolutely.
Is this a position of authority? Somebody from the court sends out this notice?
It wasn't. It was a letter simply informing the defendant that the court had acted on his motion that he had filed asking the court to reduce his suspension period, which he had been informed that he could do when he got the paperwork for the underlying DWI. Nothing in that letter changed the information that he had when he was sentenced on that DWI.
True, but I don't understand why he isn't allowed to say on the stand, I was confused. And this is what confused me.
Well, he certainly could have done that. He had the option to have a jury trial, but instead chose to have a stipulated facts trial. And when he had that stipulated facts trial, he stipulated to that element, as you pointed out, and the element was he was aware that his license had not yet been restored. He could have had a bench trial. He could have had a jury trial. And in fact, in the transcript...
Wouldn't that tend also to get us into the... I mean, let's assume that this was a jury trial and that the evidence sort of had, that the evidence had come in. I mean, what would be the argument? The argument was he knew he was violating the law, but he didn't think he was violating the law that badly. That would kind of be the argument. And doesn't that sort of get into the, I mean, wouldn't the jury then have to get some kind of instruction on sentencing on what the that badly as opposed to less badly means?
Well, the jury would have had to obviously been properly instructed as to what the law was. And again, the law is clear. But if we were to go into this hypothetical trial situation, then it is important to point out to this court that in the transcript, the September 19th transcript, the prosecutor said that if this is going to go to trial, there's an officer who would testify that the defendant told the officer that he didn't have his license and in fact was going to go get it reinstated the next day. And that's in fact what the timeline shows, that the defendant was stopped on April 7th and he was reinstated the next day, April 8th. But he chose to have a stipulated facts trial, so if there's any relevance to this letter whatsoever, which again, there isn't because it goes against the current law, he stipulated to that element. And this exclusion of the letter was certainly an appropriate exercise of discretion by the trial court. It was a misapplication of the established law, and it would have misled the jury. If there's nothing further, the state will submit.
Thank you, counsel.